So to ease you back in to the afternoon, we thought that we would do the same thing that we did last year. We had Trish Hepworth, the previous person in my role, doing this last year, so it's my turn this year, to basically spend 10 minutes running through some of the more interesting and colourful things that happened in copyright over the last year. Because despite the fact that there was, the news cycle might have been dominated by other issues to some degree, last year was a pretty big year for copyright. We had the Marrakesh Treaty coming into effect. I think absolutely everybody has to agree that was fabulous and, really amazing achievement after many years for many people. Australia had its first site blocking case. Very interesting to see where this leads, a big change for everybody. We actually tried to have somebody talk about it, didn't work anyway. Google Books was finally concluded. 10 years that has been going on. And whether or not you agree with the conclusion, you've got to admit it's good to have it finally settled. Singapore started what some people called, to quote directly from Paul Keller, who's a very big wig in Netherlands in the copyright, the best copyright review ever. A very comprehensive review was being put forward. And of course, the Productivity Commission report, of which we've already heard a lot. So those are some of the important things that happened last year. But we're not really so concerned about those as some of the more colourful things that happened last year, because that's the fun thing about copyright compared to, well, I was going to say compared to patents, but patents has amazingly wacky things. But copyright certainly has some very fun and wacky things going on. And some of these are very serious with only a light edge, and some of them are less serious and just light all the way through. So as with everything else last year, it starts with the New Conservatives, the rise of the New Conservatives. And the amazing thing is the New Conservatives don't seem to have a very strong grasp yet of copyright law. Maybe it's because they're new to the scene. But first of all, Pauline's website was stealing whole slabs from Wikipedia. Then Melania was stealing stuff from Michelle. And then Donald Trump Jr. was stealing from photographers. So the only thing I can take out of this is that there is a real opportunity for the Copyright Council to a very lucrative opportunity ahead in terms of an alt-right Copyright 101 course. So that's my advice. And to continue, but we can hardly blame them because once, you get the Conservatives involved, a lot of people seem to get confused about copyright. So Richard Prince, of whom we've already heard today, who clearly knows a lot about copyright, nevertheless, some people might see he might have been a bit confused when he decided about his rights and the legal effects of them, when he decided to disavow one of his artworks that Ivanka had bought and displayed in her thing. He basically got online and said, I no longer own this artwork, this is not my artwork, which might be possible, particularly in the US. I think they're pretty good at letting you abrogate your rights there, harder here in Australia, but they do have common law moral rights. So the question is, what is the effect of him saying I disavow? Could he raise the right of false attribution to say that he should no longer be attributed to that picture? Or maybe he could say it was derogatory treatment of his picture for Ivanka to have it in her house. I don't know, but this is, it all raises so many questions. Then, strangely, a bit unusually for copyright, there was a lot of fashion last year as well. We had claims that Kate Middleton's wedding dress was copy, and that's really just a he said, she said. I'm not sure that we're ever going to know the truth there. We had a lot of excitement around cheerleaders' uniforms and whether or not they were copyrightable. Not yet decided, still waiting to hear, but it is trying to deal with the overlap between copyright and designs, so good luck with that one. And then there was the question, again unresolved, as to whether or not putting graffiti on Katy Perry's dress is justified under artistic freedom. That was the basis of the fair use claim put forward by the person who was challenged, the designer who was challenged for using the graffiti artist's graffiti. Again, we don't know, we will have to see. But one thing we do know is that you can make a legal parody of a Louis Vuitton bag, as long as you're not fooling anybody. That was literally what the court said. Major part of parody was to make sure you're not trying to trick anybody. Everybody knows it's not a Louis Vuitton bag. There you go. So there are also a whole lot of cases that that helped us to define sampling in particular, not just in music but in video. There was the case that said to us that 8 seconds of cricket is a substantial part of a match, despite what cricket detractors might say. And that sharing it was not a fair dealing. So you can't do that. On the other hand, you can share 0.23 seconds of a horn solo, apparently, in an extremely well-selling song, that's Vogue, and that could be a fair use. And you can, in Germany, more impressively, you can share up to 2 seconds, I think it was 2 or 20, no, it was 2 whole seconds of a Kraftwerk song. They said, again, justified artistic freedom, very important, fair use. There you go. Though not they have fair use in Germany, they used artistic freedom, I think, anyway. There you go. So we've had some clarification on sampling. Actually a really big deal in copyright circles. We also know that in terms of, sampling / inspiration, you can, whether or not you heard a riff, before, does not, if it's a really common riff and it's used all the time, the fact that you might have heard it in somebody else's song does not mean you can't include it in your song in one of the most famous guitar riffs of all time, the introduction of Stairway to Heaven. So we know that for sure. That's probably good news. On the other hand, if you're going to copy the style of a former artist, even if you don't copy any of the actual notes, apparently that's illegal. So these two seem a little bit confusing with each other, and I have to say the American musicians are still concerned about that second one and are trying to change that decision. So we'll have to see if that sticks, but interesting to see. Not to leave literature out, because there's been some literature stuff, a little bit less obvious, I think, this time. We've had remixing, we've had adaptation, we've had cliff notes, but now we have fattening. I think his name is De Banff. There was a poet and author down in Latin America who took Borges's famous The El Aleph, 1920s or 40s, somewhere around there it's from, and re-released it with an extra 4,000 words. And he's been challenged. We don't know yet, once again, if that's legal or not. It's clearly a re-release. It's clearly an interpretation. He's claiming it was, artistic interpretation. Apparently, most of the words were adjectives. So there you go. I don't know if that'll weigh into the thing. Oh no, De Banff is the second guy. I've gone with the other guy. His name is longer. The other guy, the De Banff guy, he is trying to challenge Google using the phrase, actually I'll read this one because it's very specific. There are about 2,500,000,000 heartbeats in a lifetime. You should feel every one of them. He's pretty sure that that infringes on the philosophy. He did actually in his court filing say philosophy of his Live Life to the Max book, which says how to live the next 2 billion heartbeats of your life to the max. Again, we haven't seen if this has gone anywhere. It's been filed. We'll see if it goes anywhere. But I did look it up, and that whole 2 billion heartbeats in a lifetime thing, 100,000 reuses on the internet. So anyway, we'll have to see if that actually sticks or not. We did find out some great things about the public domain this year as well. My favourite bit of the copyright, public domain. So the public domain, we know now that photographs taken by monkeys are in the public domain. That's great, no matter how much Peter doesn't want them to. We also know that languages created by a human, like more recently, probably aren't, or at least they can be a substantive aspect of a complete work that you need permission to recreate. No matter how big a fan you are, you still need permission. So there you go. No Klingon movies for us unless we get permission. Though that did settle, but the early stuff was pretty big. And we also know this is possibly, some people were sad about this one, but basically we know that if you donate all your photos to Google, to the public domain, and I apologise, I haven't written down her name. Anybody remember her name, the photographers? It's like Chestworth or something like that. Anyway, she donated almost all her photos to the public domain and then found Getty Images selling them. In fact, Getty Images, she found out because they sent her a takedown notice for her own website of her own photos that she donated to the public domain. Some like Warner Brothers who sent a takedown notice for their own website as well, and Amazon's website and all these other websites that they'd licensed to. Anyway, that's not necessarily Warner Brothers' fault, it's Voible's. Anyway, the sad outcome of this case is it turns out that Getty Images were totally within their rights. She's donated them to public domain, they're really in the public domain. Getty Images can scrape them and sell them as much as they like, even if they're available free somewhere else, because they do it with other things, so there you go. Here closer to home, we found out that if you want to watch a boxing match, you should probably only watch it with 2 or 3 of your friends and not 200,000 or 300,000. The good news is I think that message has got through, and I think it will probably stick without too much litigation needed. And we also had the death of 3 strikes, and somewhat like its 6 strikes cousin in the US. What makes this one funny is that basically, as Graham Burke puts it, because it costs $16 and $20 a notice to send out, that's why 3 strikes basically died in the end. And there was a lot of tension between this number and working it out back and forth. But in the end, even Graham Burke admitted that you may as well just be giving the pirators a DVD. So it wasn't worth doing, so it died. There you go. And then finally, because we're keeping this short, I wanted to get in something about rights reversion. It's been a really big thing. The rights reversion rights in the US, for people who know, let people reclaim their material after 35 years, and it's only a fairly new right, so it's just coming into force now. So the last few years, a lot of movement, and Duran Duran has tried and been told that their UK contracts overrule it, and Paul McCartney is trying to, in advance, get clarification as to whether or not his contracts are going to overrule it because they all want to take advantage of this right. But I couldn't find anything really funny because it's such an important, serious issue. So I thought I'd just give you some pictures of Duran Duran and Paul McCartney looking very serious. So there you go. And that's that. That was Copyright in 2016, and I hope that you all enjoyed it.